All right, let's go on the record. Tony, are you ready?
Judge, I'm ready.
Let's go on the record on DC 24-21142, Ortiz versus Fiesta Mart Inc. Counsel, make your appearances.
This is Brandon Samuels with the Raleigh Law Firm here on behalf of plaintiff Paula Gomez-Ortiz.
And this is Mary Alice Cox on behalf of defendant Fiesta Mart.
All right, you may proceed.
Thank you, Your Honor. This is a motion to compel arbitration that we filed on behalf of Fiesta Mart. The plaintiff in this case was an employee. We filed with our motion to compel arbitration a copy of the entire benefits plan, as well as the signed acknowledgement in
Sorry, just
Spanish.
I
And
am Judge.
yeah, there
sorry?
was something interfering. I apologize.
Oh.
You can keep going. Ms. Cox, go ahead.
Thank you, Your Honor. So under the law, we have to prove two things to have this compelled arbitration. One, we have to show the existence of a valid arbitration agreement. We've produced evidence of that. And two, we have to establish that it falls within the scope of that agreement. And we have done that. This is an employee. We're a non-subscriber. We've produced all of the evidence the law requires. Under Texas law, under the Texas Supreme Court case law, arbitration is favored, and it's to be
So
interpreted.
it seems to be their main argument is that he didn't actually sign the arbitration agreement. Is that, I mean, that seems to be his main argument, right?
Well, I think they haven't established how the signature ended up on the agreement if they didn't. And then secondly, they're arguing about it being in Spanish, and the HEB versus Sains case that we attached with the notebook that we sent to you establishes that that's not sufficient. And then second, the mission case that we sent to you establishes the ratification. So once you accept the benefits under it, then you've ratified it. So even if they're trying to claim, I didn't know or I didn't sign it.
He cites the Reyes versus, plaintiff cites the Reyes versus Storage and Processors Inc. case. How do you distinguish that case?
I think that's the case that deals with the motion for summary judgment, Your Honor, as opposed to a motion to compel arbitration. It's an older case that deals with the motion for summary judgment. This is a motion to compel arbitration, and the cases that we cited are motions to compel arbitration.
According to what he cited here, he says, I don't have a copy of the case in front of me, but it said the court reasoned that when appellant signed the acknowledgement letter, that it failed improperly notified appellant of the terms of the agreement, as the information about the benefits plan itself was in English, not a language understood by the appellant. Subsequently, the court reasoned that appellant was not bound by the arbitration agreement based on the signature. I mean, so at least in its briefing, I haven't read the case. It seems to be an arbitration case.
Well, Your Honor, the Mission Petroleum case that we cited and sent to you, in that case, they were also stating that it wasn't signed. And the court said, and what they held in that case was, okay, well, even if it wasn't signed, you accepted the benefits under the plan, so you ratified the agreement. And here, once the plaintiff accepts the benefits, even if you say it wasn't signed, which we dispute, but even if you say it wasn't, the benefits were accepted. So once the benefits are accepted under the plan, they've ratified it. So the whole plan, part of the plan is, hey, we don't have comp, but we're going to give you benefits under the plan. We're going to pay you lost wages. We're going to pay you medical bills under this plan. And if there's a dispute, we go to arbitration. That's the agreement. And the plaintiff accepted those benefits under that plan. So that's ratification of the agreement between the parties. And that's the Mission Petroleum case.
All right, response?
Yes, Your Honor. As cited in the Reyes case, ratification requires three different elements, approval by act or conduct, which we could agree that accepting those benefits is that act or conduct. The other two elements are with full knowledge of the facts of the earlier act and with intention to give validity to the underlying earlier act. Here, as we argued plaintiff was unaware of the benefits package because it was signed on her behalf. Well, not on her behalf, but on her name by the supervisor with no understanding or information regarding the arbitration agreement. When she received the benefits, she wasn't receiving the benefits with the agreement and knowledge of the arbitration agreement, only that she was receiving payment. As in Reyes, where the appellee received the benefits under the package, the courts ruled that without knowledge of the underlying agreement, it was not receiving or ratifying the underlying agreement, which was an arbitration agreement in that case as well, Your Honor.
And Ms. Cox, you said you submitted a notebook on this?
Yes, Your Honor. In response to your order from last week, we submitted all of the briefing, the HEB versus Sains case and the Mission Petroleum case, as well as the case that plaintiff sent to me to include. So that is all of the briefing, and then the 3 cases cited, primarily relied upon by both parties, is in that notebook that was FedExed to you on Thursday. So you should have received it on Friday.
Thank you so much. Any other argument you guys want to make today? I'm going to take this under advisement.
No, I just would cite to the language, Your Honor, just like in the Mission Petroleum case, the plaintiff in this case has not returned any of the benefits after getting a counsel and knowing about this. And so in that case, the Mission Petroleum case, the court said, the plaintiff has not returned any of the payments made to him or any of his made on his behalf. And even after we sought arbitration, and then the plaintiff cannot avoid the arbitration agreement because he has accepted benefits under the plan. So that case, I would ask you to just review, Your Honor, because the language in that is very similar to here, where they were making similar arguments. But the case, you don't have to have a signed agreement. We do, but even if that's disputed, you don't have to have a signed agreement under Texas law for the arbitration agreement to be valid. And this plaintiff in this case did accept benefits, which is sufficient to ratify it. There was a valid arbitration agreement. This falls in the scope. There's no question under Texas case law. The arbitration agreement controls, and this case needs to be sent to arbitration.
All right. Anything else, Mr. Samuels?
No, Your Honor. I believe in our response, we addressed all of defendants' allegations in regards to the signature and requirement of a signature based on the argument of fraud, Your Honor.
All right, I will go ahead and review that, and we'll try to get you ruling within the next month or so. You guys have a great day, okay?
Thank you, Your Honor.
All right, thank you. Bye-bye. Okay, we're going to take a quick break, and I'll reconvene in about 5 minutes.
What? Uh-uh. I just need to get in here. I was just in here. Okay. But why can't I get back in? I'm trying to call her and she's not answering the phone because I'm trying to tell her something's going on with my phone and you're not answering your darn phone.
Miss Tanet, you're not on mute. Everybody can.
I'm sorry. I'm trying to get, I don't know nothing about this. I'm sorry, but I'll get on mute.
Okay, guys, let's, I think our next case is, Velocity Investments versus Monroe. Anyone here on that case? Velocity and, oh, am I unmuted? Let me see. Rhonda, can you hear me? Okay, anyone here on Velocity Investments versus Monroe? Okay, how about Osseous Fusion Systems versus Holland? Anyone here on that case?
Yes, Your Honor. I'm Doug Hafer on behalf of Osseous.
Kevin Madden on behalf of Defendant Neurostructures Incorporated, Your Honor.
Okay. Tony, are you ready?
I'm ready, Judge.
Let's go on the record on DC 231043. Counsel, make your appearances.
Doug Hafer on behalf of plaintiff Osseous Fusion Systems.
Kevin Madden, Your Honor, on behalf of the movement and the defendant Neurostructures Incorporated.
All right, you may proceed.
Thank you, Your Honor. Your Honor, I know that you have read the motion for new trial and the response and are intimately familiar with some of the procedural issues in this case. Rather than simply recite again the motion for new trial, I just wanted to point out a couple things, if I could, Your Honor.
Thank you.
First of all, I think based upon what the requirements are of the case law, Your Honor, I think that the movement has easily cleared the burden of a meritorious defense, Your Honor. It is not our requirement to essentially prove our case or to have a trial in our motion for new trial. It is basically to establish, which we have done by declaration evidence, Your Honor, that we dispute a lot of the allegations in the petition of Osseous, and that Neurostructures Incorporated, if it has the opportunity to testify in this case, will be able to provide controverting evidence to those. As to the issue of
Well, I have one principal question was
yeah, Sean.
So we had a trial setting. There was a Mr. Hill, I guess, that was supposed to be representing the defendant. Mr. Hill, we tried to get Mr. Hill on the phone, find out why he wasn't at the trial setting. We never could. And I didn't see anything in the briefing that discusses why Mr. Hill wasn't there. And so why wasn't Mr. Hill there, and why wasn't he answering his phone?
And I'm looking at part of our brief here, and I will represent to the court. I haven't been able to speak to Mr. Hill either. How it was conveyed to us was that through an intermediary, Mr. Hansen, who was Osseous's representative, contacted him and was informed that there may have been an accident related to some severe weather on the date of the trial setting, and that was the reason that Mr. Hill was not able to appear for the trial setting. That's what's in both our motion and in the declaration of Mr. Hansen. As I said, Your Honor, I have not been able to contact Mr. Hill, to verify any of that, but that is in the declaration of Mr. Hansen as to I think the understanding was on the 3rd, Your Honor, you instructed Mr. Hansen, you got to get a lawyer because you're a corporation. His testimony is, or his declaration is, I contacted Mr. Hill, who said he would show up for me on the 4th, and he didn't show up. So that is the information I have for you related to that issue, Your Honor. What I will say, Judge, is there's a lawyer in the case now for Osseous. I'm not going anywhere. I can't go anywhere unless you let me go somewhere, Your Honor. And I do not intend to file a motion to withdraw. I have brought my calendar, Your Honor. I'm ready to pick a trial date, and I'll represent to the case. I need 2 hours probably to present my case in chief, to defend Osseous. So we are ready, willing, and able to abide by all the requirements. I don't know what happened before, Your Honor. I can't fix any of these things that happened related to the original trial setting. All I can say, Your Honor, is if, as I'm sort of getting the sense in the response, we've had enough of this is just gamesmanship, this keeps going on and on, that will not happen, Your Honor. We are ready and willing to have a bench trial at an agreeable date. As I said, I brought my calendar, that works for the court and works for the plaintiff, Your Honor.
All right, response?
Your Honor, as the court has touched on, we showed up for trial after being advised to do so, but it wasn't just that trial date or the day before where we were advised to come down, and that Neurostructures was supposed to have counsel. This is the second time I've had a default issue. A default was taken in August of 2024. November 6th is set aside. The lawyers who represented Neurostructures at that time withdrew on December 11th. We filed a motion to strike their pleas because they didn't have an attorney on February 21st. On February 28th, we got notice from the court that we were being called down. Then March the 3rd, a specific email stating if Neurostructures did not appear, that a default would be taken, appear with an attorney. There was even a telephone conference with the court at 1:30 that on March 3rd, which the court also told us that we needed to be in before the court with attorneys on the 3rd. On the 4th, Osseous showed up ready, willing, and able to go. We were, and Neurostructures, while Mr. Hansen himself appeared, he claimed that he had a lawyer, but this elusive Mr. Hill never called, never contacted me, never contacted the court, never made a notice of appearance. This was not a case of, this was a case of conscious indifference. 2 times this has been defaulted. No lawyer appeared, and this position that we've set up a meritorious defense is also not true. This is it. While yes, it is technically supported by a declaration, it's completely speculative, conclusory, and constitutes no evidence as a matter of law. So on all counts, this default should stand, and if what defendant believes is true, they can take that up with the Court of Appeals.
Response?
Yeah, my response to that, Your Honor, I mean, at the basic level, this is a due process issue here. I understand that there is frustration and anger, okay, at Neurostructures because, and my understanding is the first default was not because they didn't have a lawyer. Okay, the first default was because an answer hadn't been filed or some other issue. On the issue, and to the issue of conscious indifference, as counsel said, Mr. Hansen showed up, okay, for trial. I understand that there's not Neurostructures had to have an attorney. It's a corporation. But they solved that problem, Your Honor. And to essentially say, we don't want to spend another 2 hours, okay, having a new bench trial, take it up with the Court of Appeals, Your Honor. I think, I think the most efficient way, there's no jury trial. This is going to take a week, Your Honor. This is going to take some more of the court's time. I understand this. And once again, I can't fix what happened before, Your Honor, with this. But I think they've clearly met the issue, okay, of Craddock. This all comes down to whether the court accepts, okay, that this was not conscious indifference, okay, that this was a mistake or an accident. I think that is established by the fact that Mr. Hansen actually showed up. I wish Mr. Hill had been in communication with me and other people, but he hasn't. But as I said, that particular issue has been resolved, Your Honor, and we can have a trial and they'll have a lawyer. What we can't have is a situation where they get defaulted without having had the opportunity to put on their evidence and essentially take this insouciant view that let the appellate court handle that.
They did have the opportunity to put on a defense. They could have gotten a lawyer way before when they did. They were notified multiple times that they needed a lawyer. So to say that they didn't have the opportunity, they definitely had the opportunity. They just didn't take advantage of it. That being said, my inclination is usually I would just say, what is the cost of the default judgment? There's been a lot more going on here. I would say, I would grant a new trial with the payment of maybe $5,000 in attorney's fees or something like that. What are your thoughts about that, Mr. Hafer?
Yes, Your Honor. Well, I understand the court's position, and to try and cure the prejudice, I have an affidavit showing that for the 2 defaults, we had incurred $26,000 in attorney's fees. We had to prepare this case as if we were going to try it on the 4th. And so it is more than 5,000. So I would say both combined, all the work that we had done accumulated at 26,000.
What is the dispute in question here? How much are we fighting over?
I think the amount in your judgment, Your Honor, is approximately $76,000.
That's correct. It's a little bit, I mean, give or take, but that's about right.
What if we split the baby and did 15,000 to be credited towards any final judgment if that occurs? Mr.
Well,
Matt, what do you think? Mr. Madden?
Yeah, I don't have an objection to that, Your Honor. I can't speak for us, but I don't have an objection with that, Your Honor, as a way to work this out. I think that would clearly, cure any prejudice here, related to the issue. Credit against the final judgment.
Let me make it clear that the payment of the $15,000 would be the condition for granting the new trial. So the new trial would not be effective unless you actually receive $15,000, Mr. Hafer. So, and it would just be a credit towards whatever attorney's fees you recover at trial if you do recover attorney's fees. And so
I understand, Your Honor.
Does that address it? Are you okay with that?
I'm sorry, is that question to me, Your Honor? Is that to
Yeah.
Mr.? Yeah, Your Honor, yes, that is acceptable.
Yeah, that's my understanding as well, Your Honor. And so I think where we're on the 12th, Your Honor. I think the motion would be overruled the operation of law, I think, in about 6 days, Your Honor. So my understanding is, do we have to make that payment by some date certain in advance of that date, Your Honor? And then the motion for new trial would be granted.
What is the deadline again?
I think it was granted, the order is March 5th, I believe. So that would bring us to May 5th, I think it's going to be May 20th or May 19th, Your Honor. I think that's 76 days.
So why don't we do this? Rhonda, you there?
Yes, Judge, I'm here.
Let's set a status conference on this case for Friday. You need to get the payment, get a new summary, get a new trial order. Mr. Hafer presented to me with that language, and then the payment of the 15,000 needs to be paid by Friday. If they pay it, great. If they don't pay it, then we deny the new trial.
Very good.
All right.
So Friday at 9 o'clock, in person or remote. And if you guys reach an agreement and get the order signed, well, actually, no matter what, I want to be able to meet with you because then we can discuss the trial setting.
All right.
Very, very good.
All right. That would be great. All right. Well, I appreciate that, Your Honor. That we'll get with my client. We'll get that arranged. May we be excused?
May. You have a great rest of your day.
Thank you.
Your Honor.
Stellavan versus Maciel.
Yes, Your Honor. Madeline Gertis for the plaintiff.
We can't see you. Your lighting is really bad. I don't think so.
1 second. Let me turn on my big office light.
Okay. That's okay. It's okay. It's just very hard to see you. All right. Tony, you ready?
Ready, Judge.
Let's go on the record on BC 2422476, Stellavan versus Maciel. Counsel, make your appearance.
Madeline Gertis for the plaintiff, Ms. Tonette Stellavan.
All right, you may proceed.
Ms. Stellavan, please state your full legal name for the record, please.
Are you calling any? Whoa! You have to call the witness first.
Sorry. Your Honor, may I call Ms. Tonette Stellavan to the stand?
You may. Please raise your right hand, ma'am. Is that your right hand or your left hand, ma'am?
Oh, hold on.
All right. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may proceed.
Please state your full legal name for the record.
My name is Tonette LeJune Stellavan.
Do you understand that your testimony right now is under oath?
Yes.
Please tell the court your age at the time of the accident that occurred on November 18th, 2024.
I was 54 years old.
Yes, ma'am. Please briefly describe how the accident occurred.
So I was at Bliss Adult Store. I was coming up the aisle. As I proceeded to keep coming up the aisle, the gentleman, he backed out real fast until on my passenger side.
And please describe your injuries.
It's my passenger door is completely total damage in. I cannot open it. No use of it.
What about your bodily injuries?
My body injury is my back, the middle part of my back. I was been getting shots in my back for, I have problems with my back now.
Yes, ma'am. So just to be clear, you're suffering from back pain.
Correct.
And just going over your medical providers here, do you recall treating at Greater Texas Orthopedic Associates?
Yes.
Does about $25,307 sound about right for the treatment that you received?
Correct.
Do you recall treating at Memorial MRI?
Yes.
Does about $5,512 sound about right for the treatment that you received?
Correct.
Do you recall going to Advanced Dallas Hospital and Clinic?
Yes.
Does about $16,852.38 sound accurate for the treatment you received?
Correct.
Do you recall going to Advanced Diagnostics, doing business as Cobra Imaging?
Yes.
Does about $375 sound right for the treatment that you received?
Correct.
And can you please explain to the court how you felt since your last medical treatment?
I've been, my back and everything have been very bad for me because I work in the medical field. I am at this moment, I went down to a caregiver from a CNA to a caregiver, and I still have to lift residents. So it's really hard for me to really lift the patients. I've been doing this for 34 years, and this is a passion of mine, and I love it.
Yes, ma'am. Did any of your doctors that you've treated with tell you that this pain would continue?
Yes.
And how does the pain affect your personal life at home?
Some days I cannot get out of bed. I will have to roll, lay on the floor for about 5 to 10 minutes until the pain go away. Treat myself with just do a hot compress on my back until that pain relieve, and then I'll be able to get up and walk and move around. By the end of the day, I'm back in that same position.
Yes, ma'am. So how would you say that this limits your ability to do chores around the house?
It's kind of hard. If I want to move the couch or move the furniture, it's very, very hard. To sweep with the broom, probably about 2 or 3 minutes. I'm old fashioned. I like the broom. I don't like vacuum cleaners. So I got to find a different way.
Yes, ma'am. Does this limit your ability to be active with your family or your friends?
Some days it does, and some days it don't. It varies.
And is this pain still affecting you today?
Yes. This morning was very hard for me. I got up kind of at 4 o'clock this morning from the pain. I couldn't do nothing but lay on my side and have my fiance to rub my back, and it still didn't work. So I don't know what to do from here.
And how does your injury affect you mentally?
Mentally, because I love to work. I am a woman of working, and it affects me of knowing that I can't give the proper care for my residents or for myself as needed.
Yes, ma'am. Your Honor, plaintiff moves to introduce plaintiff's medical and billing records. Due to a clerical error, these records were not previously filed. I'd be happy to share my screen, or we can submit a amended motion with these as exhibits.
You need to go ahead and email those to my court reporter,
Okay.
Tony Rieger. Tony, do you want to go ahead and put that in the chat, your email address?
Okay. Rhonda usually does it.
Yes, I can do it for you. I'm doing it right now.
Whatever way you guys want to do it.
And may I proceed before emailing these, or do you want me to email them first?
No, that's just make sure you do it.
Yes, sir. All right, Ms. Tonette. So are you asking this court to award you $48,046.38 for past medical expenses?
Yes.
And are you asking this court to award you $30,000 for pain, suffering, and mental anguish sustained in the past?
Yes.
And are you also asking this court to award you $30,000 for pain, suffering, and mental anguish that is reasonably probable in the future?
Yes.
Are you asking $20,000 for past physical impairment?
Yes.
Are you asking this court to award you $20,000 in future physical impairment?
Yes.
All right, Your Honor, I have no further questions. Thank you.
All right, the court will grant judgment as requested. Were you also asking for any type of, she testified about some kind of repairs, but there's nothing in here about repairs. Was that already paid for?
Yes, sir. We don't handle the property damage aspect of this case. We're only representing her for her physical injuries.
Okay, then I will go ahead and grant the judgment as requested. I'm signing that right now and sending it to the clerks. You have a great rest of your day, okay?
Thank you.
Thank you.
Second, you guys have a great rest of your day.
I'm trying to, it's hard. I'm not very good with computers.
That's okay. You have a great day.
You too, sir. Exit out. What do I do here?
Next case is
okay.
Cook. Are both sides here on Cook Concrete versus WB Contractors?
Joe Ackles and Larry Ackles here for plaintiff, Your Honor.
Your Honor, Michael Dingman and Ryan Frankel here for defendants.
All right, Tony, you ready?
Judge.
All right, let's go on the record on DC 24-19714, Cook Concrete LP versus WB Contractors of Texas. Counsel, make your appearance.
Yeah. Joe Ackles Sr. and Larry Ackles Jr. here for the plaintiff, Your Honor.
Your Honor, Michael Dingman McGuire Woods. I have my pro hoc vice motion pending with the court on behalf of the defendants.
And Your Honor, Ryan Frankel, also on behalf of the defendants with McGuire Woods LLP. I'm barred in the state of Texas.
All right, so let's deal with the Pro Hoc VJ first. I looked at the Pro Hoc VJ motion, at least the version I saw, maybe there's an amended version I didn't see, did seem to be incomplete. Is that being opposed? Is that, I didn't see what exactly the opposition was, but it did seem to be missing some things. So is there an opposition to the Pro Hoc VJ?
Yes, Your Honor. Joe Ackles Sr. speaking. Judge, when you talk about these things with a lawyer, I asked it respectfully that we do this in what we used to say in chambers, so that we wouldn't publicly say things. But yes, we do oppose that motion, and I would like to address some issues with the court, if possible, virtually in chambers.
Okay. Let's see. Let me create a breakout room real quick.
Your Honor, may we make a request that this, let me clarify. What I don't want to put words into Mr. Ackles' mouth, but I think that he's probably going to say things that he doesn't like very much about Mr. Dingman. We'd like those to be on the record. We do not think it appropriate to have these remarks be in camera. There's nothing, as far as I know, that's going to be confidential about these.
That's fine. I think Mr. Ackles is trying to be old school. If you want it on the record with all these folks here, that's fine.
We would prefer that. Thank you, Your Honor.
All right, let's go forward. Mr. Ackles.
Thank you, Your Honor. I'd have to give you a little background, Judge, if you don't mind. I've been a mediator, a lawyer for 43 years this year, and a mediator for 35 of those years. And one thing I've learned in mediation, I've mediated many cases off your docket most successfully, but one thing I learned is that 98% of all lawsuits settle before trial, and it's best to try to extend an olive branch right out of the chute before you file suit and see if you can work things out. So in the midst of my client, Cook Concrete, being terminated from this project of these apartment complexes, I reached out to Mr. Dingman, who's a Virginia lawyer, and asked that we try to pitch a peace tent before litigation and negotiate a possible settlement. And the circumstances of the lawsuit are important to note that this is a building of 2 apartment complexes, the Katy Trail project and the Fairview project. And in particular, the Katy Trail project, my client was the concrete subcontractor for the building of the apartment complex and the parking garage and the deck work and all the concrete work. And as you know, one of the first things my client was to do was put the piers in, and the piers, that most people know, are the foundation of the building, which holds the building and its integrity together. So they were late. The general contractor was late. My client made his bids. They made material changes to the schedule and changed the scope of my client's accepted bid. They delayed my client's access to the space. And just by way of example, because this is critical to everything we're going to talk about today, the piers for this project were changed from 10 feet to 4 feet. And that's significant. It was a material change. It changed the scope of work. When you're putting in piers, you know, Judge, they've got to go into the bearing strata, what it's called, rock or shale. And if it's only 4 feet deep, it's very important that the piers be done right and to the architects and engineers' specifications, and the slurry or the bearing strata around it that's replaced once the piers are put in has to be met to the specific specs. And if you don't mind, Judge, I'd like to show you what I'm talking about. If you could.
We're just doing the Pro at VJ right now. I'm not sure what you're doing.
Your Honor, may I?
No, let me finish. That's what I'm talking about, Judge, because I wanted you to see that the pier problem in this case is what caused the fight with Mr. Dingman. Okay. And I just wanted to show you, if you don't mind.
I saw the picture.
Okay. The guy standing next to the pier is his whole body, so that's the extent of the pier, and they're digging all around it. And Cook found out that they were putting the refill of improper improper materials. He brought it to the attention of the general contractor. They affirmed that it was improper. They made the plumbers and electricians excavate everything and put in the proper fill. And then after that was done, over the watchful eye of the architects and engineers, Cook discovered they were excavating further around his work, and he asked for more proof, because he's warranting this work. He asked for more proof that this work was supervised and monitored by the architects and engineers, and the defendants clammed up. So they fired him off the job. They withheld $1.8 million of his retainage and other expenses, and there's some other issues with regard to damage. So with that information, I went to Mr. Dingman. I said, let's pitch a peace tent. Let's talk about resolution. And Mr. Dingman's response to me was that we were extorting his client. And he sent me an email asserting somewhat like that. And then he filed a claim, a counterclaim, an answer, and disclosures using the word extortion. And in my book, that's improper. He threatened me and my client with extortion. And I tried to call him on it, said, you're wrong about this. His position is the piers are unrelated. So we sent out discovery. Mr. Frankel called me to say, let's discuss the discovery. We're not going to produce anything related to the piers. It's not relevant to the lawsuit. I said, we talk all about the piers in our lawsuit. It's related to your withholding of $1.8 million because of the peer issue. It's the cause of the delay that you're suing my client for $1 million, the peer issue, and yet they don't want to produce any documents related to the peers.
Your Honor, I'm gonna have to object to this. At this point, Your Honor, we're just, Mr. Ackles is giving an opening statement. If we could just deal with the pro hoc portion of this.
Yeah, where are we going with the pro hoc here?
So I've talked to Mr. Dingman on a couple of occasions and Mr. Frankel 2 or 3 more times. Mr. Dingman does nothing but threaten me and hang up on me and insist that if things be done his way, and he wants me to be held to a standard of Virginia law, which requires meet and confer. And I tried to meet and confer with him. In fact, last Thursday, I called him and said, let's bury the hatchet. Let's let bygones be bygones. Let me extend an olive branch. He would have none of it. I asked him, I think the judge is going to make us talk about the request for production. We should talk about them all right now. He refused. Said he's not going to talk about anything with me unless I withdraw my motion to compel. I said, that makes no sense. We need to discuss. He refuses to discuss it with me. His work is obstreperous to us trying to resolve issues that I can't seem to communicate with him because he wants things done his way. And he continues to threaten us with extortion. I think that's wholly improper. I'm not sure he's read the Texas Lawyers Creed.
Your Honor,
so for those reasons and the way he has behaved and treated us, I have to oppose plus he's got Mr. Frankel, who's Texas counsel.
Your Honor, since it's our motion, can I please address some of what Mr. Ackles said?
Let me ask Mr. Ackles a question. So you don't have any problem with the form of his motion?
I do think he's missed the detail of the form that's required in a pro hoc vice. I don't have all those issues in front of me, Judge. I can look at it again.
Because pro hoc vice has to have attachments on his, the pro hoc vice motion, I'm not going to go into what Mr. Dingman has done or not done. I don't know that that's really appropriate for a pro hoc, but it doesn't have all of the attachments that, unless there's another one that's been submitted. Let me see.
Your Honor, I think I can address that since I prepared both of them. So we prepared a motion for Mr. Dingman's own motion, and then we prepared my motion in support of Mr. Dingman. I will admit I made a clerical error in that I did not attach the fee that we paid to the Texas State Bar that is required for a pro hoc vice motion. We've done this exact motion multiple times as we represent Hilton Franchise and have to do this with other Virginia lawyers. So I'd represent to you that the motion is indeed complete, the both motions with a proposed order, except for that one small caveat that we did unfortunately miss the fee, though we did pay that fee. And I'm happy to email that to your clerk.
So you filed this as 2 separate motions? I've never seen it done that way.
Your Honor, that's the way I've always done it, which is it's supposed to be a motion from the barred attorney who is basically sponsoring the attorney who is trying to seek pro hoc admission, as well as the sworn motion from the attorney seeking pro hoc admission. So we did 2 motions and we had a proposed order, which basically grants both of them and allows Mr. Dingman to appear pro hoc vice. And in any event, Your Honor, to the extent there were some type of clerical error, I would respectfully ask that you grant leave for Mr. Dingman to argue these motions, pending his pro hoc vice, considering as much as I'd love to get into to respond to most of what Mr. Ackles said, I think Mr. Dingman is probably better equipped to do so. And if we have to, if Your Honor or Mr. Ackles thinks the form of the pro hoc is improper, we're happy to amend. But at this time, we would still ask that Mr. Dingman be granted leave to argue the matters before you today. And prohibiting him from doing so would greatly prejudice our clients.
Okay, well,
Your Honor, this is Mr.
Say
Dingman.
this.
Could I respond to Mr. Akles? And
No, you don't need to. This is purely, from my standpoint, it's been years since I've had a Pro Hoc VJ motion actually challenged. My recollection is that there's a requirement that you have to submit something from the bar where they're from, saying that there's no disciplinary history and all that kind of stuff. I have not had this issue come up in quite some time, so I'm trying to look at the requirements for that, and I can't find it on Connors, unfortunately.
Your Honor, to be clear, he does, and listen, hand to God, I could be incorrect, but my understanding was that Mr. Dingman need only swear that he has no disciplinary history, and that what we did need to include was directly from the State Bar of Texas, which was a fee. And again, that was my error for not including that on either of the motions, which again, the fee has been paid and we're happy to supplement.
Mr. Ackles, are you contesting that wasn't properly done? I'm trying to find it. I thought it would be in O'Connor's Pro Hoc VJ. I've dealt with this many years ago. I mean, it sounds like you don't like the way he treated you. You're not the first time I've seen that. I don't think that's a basis to challenge a Pro Hoc VJ. I do think that you have to have something in there from the bar, but I can't find it right away.
Your Honor, may I respectfully request that we then, at the very least, proceed with the different motions here, and while Mr. Dingman's Pro Hoc is pending, and you grant him leave to argue those motions, and we can sort out the, I guess, procedural issues with the Pro Hoc, because if Your Honor is saying that we need only follow the proper procedures, which again, we believe we did, and that Mr. Akles' comments about Mr. Dingman's, I guess, attitude at best are irrelevant to the Pro Hoc motion, then it seems as if we could just allow this to Mr. Dingman to argue if you grant him leave.
Well, we do object to the Pro Hoc VJ motion. If they do file one that meets all the requirements, we'll respond to it, Judge. My beef is not that he's been a bully. My beef is that he's threatened me with extortion, me and my client, and that's improper. And that the court, I needed to make sure the court knew that before deciding whether or not to admit him Pro Hoc VJ. And I'm like you, Judge, 43 years, I don't remember opposing a Pro Hoc VJ motion before, but it's been quite a while since I've endured something like this. So that's why we oppose this one.
So according, I'm doing a quick search on this. A reputable attorney who resides outside of the state of Texas, this is from the Texas Board of Law Examiners, and who is licensed in another state or foreign jurisdiction, but not in Texas, may seek permission in a proceeding in any particular cause in Texas court or body by following the steps set out in Texas Government Code 82.0361. That's 82.0361 and Rule 19 of the rules governing admission to the Bar of Texas, satisfying the non-resident attorney fee as a mandatory initial requirement in the process. And usually what I see is that's attached to the Pro Hoc VJ motion is this acknowledgement letter. There's an acknowledgement letter. We will issue an acknowledgement letter. I don't see the acknowledgement letter in what you submitted.
Your Honor, you're absolutely correct. That's what I was referring to with the fee that we paid, in that we admittedly got the acknowledgement letter, but it was my inadvertent error not to include it in the motion. I'm happy to supplement that, and I can do so in a matter of 5 minutes by sending it to your clerk. I could probably do it in 90 seconds. I'm not the fastest, but you know,
There's other things that have to be sworn to. He's an active member in good standing. He's not the subject of any disciplinary. I mean, none of that stuff is in there.
Your Honor, respectfully, it is.
Is it okay? I guess I didn't see it.
There are two motions, as I said. So, and I can read it for you verbatim.
Where is it in the motion then? Let me see.
So if you look at Michael S. Dingman's, and I want to share my screen with you, Your Honor. Would you mind if I did that?
Go ahead. Just give me a second.
I am sending a request to do so.
Go ahead.
Let me see if I can do this. Again, I told you, Your Honor, I'm not the fastest. So, Your Honor, you'll see this is filed on 5/5/2025. This is Michael S. Dingman's opposed motion for pro hoc vice admission.
Okay, I see that. All right.
Yes, Your Honor. So I want to be clear first that he did swear to this, and this is a declaration in lieu of a verification per Texas law. And this is where he follows exactly the rules that you just alluded to. And those are sworn statements per his declaration.
All right. I see that now. Okay. I think I got thrown by the fact there's two different motions. I just
totally understand that, Your Honor. And
all right. So this is what we're going to do. I'm going to have you go ahead and supplement this motion and we'll reconvene at 1:30 to discuss the rest of this. And maybe have you guys actually conferred about this?
I think both parties will probably, when you say this, are you referring to the pro hoc?
All the motions.
I think both parties would have very different versions of whether we conferred. Respectfully to Mr. Akles, I'm sure he doesn't take that pejoratively.
Judge, I noticed you have 20 motions on your today's docket, and I've offered last week to discuss everything in question, and Mr. Dingman refused to do that. And I told him I thought the judge would order us to go talk about all this stuff so we won't waste the court's time. He refused to do that. And so I do think we have not fully discussed everything because Mr. Dingman refuses to do it.
All right, you guys I'm going to put you guys into a breakout room right now, and then you guys will be back at 1:30. We'll see you then. Sorry, Mr. Frankel. You looked a little frustrated there, but that's what we're going to do.
No, Your Honor, I understand.
All right, we'll see you at 1:30. Curry versus Burkhart-Huchard.
Good morning, Your Honor. Kyle Pugh on behalf of From the Ground Up as the movement.
Good morning, Your Honor. Blake Brown Chattel for the plaintiffs. Hey, Kyle.
Hello, Blake.
And Caitlin Coker here for defendant Daniel Huchard.
All right. Did you get that, Tony, or do we need to start over?
I was writing, so I didn't get it. Sorry.
All right. Let's go on the record on DC 243270, Curry versus Burkhart-Huchard Holding or Associates. Counsel, make your appearance.
Kyle Pugh on behalf of From the Ground Up, the movement.
Blake Brown Chattel, counsel for the plaintiffs.
Caitlin Coker, counsel for defendant Daniel Huchard.
All right, you may proceed.
Thank you, Your Honor. From the Ground Up is a locally owned landscaping design firm. They installed landscaping to the Curry residence pursuant.
I'm familiar with the case. All you're fighting over today, I guess, is trying to get the water bills from January 2022 to date. Is that right?
Yes, Your Honor. And okay. I'll get right to that. Okay. The plants died shortly after installation in the summer of 2023. Our irrigation specialist met with the Curry's gardener. They went to the garage. We adjusted the irrigation system, the watering system. When we learned that the plants died, we inspected the plants. The plants died in large part, the majority of the plants, to overwatering. The watering was adjusted to be aggressive by us, but per the contract, once the project's completed, the watering is expressly the responsibility of the property owner. And that's attached to Exhibit 2, the contract. Owner's responsibilities, watering shall be the sole obligation of the owner after work is completed. The principle of From the Ground Up was presented images of the dead plants, which were.
I've read everything.
Okay.
It's fairly
and our theory, Your Honor, is that when we adjusted the watering schedule high, they never subsequently adjusted it to be lower.
Okay.
So we're seeking the data from the year before to provide a baseline.
I got it.
Okay. And the year after to compare to, as opposed to just the year of the incident. And in a nutshell, that's the motion.
Counsel. I said I got it. Let me hear the other side, okay?
Sorry, Your Honor. I didn't hear you. I apologize.
It's okay. I've read Ms. Coker. This doesn't seem unreasonable to have some comparative history. I'm not sure why how long has your client owned this property?
Oh, counsel, this is counsel for the plaintiffs, Blake Brown Chattel. They have owned it for, I think, and I'm guessing here, at least 10 years. They've lived in Highland Park for some time and haven't moved. So I'm going to say 10 years. Our issue is the requests are facially overbroad. It's not a burdensome objection because the town of Highland Park would be producing it. It's just, their contention is most of the plants died from overwatering. Ours is, as Mr. Curry testified multiple times, it's from the heat. So we think, a comparison right before and right after is sufficient. And we agreed already to a full year. He signed, the waiver for the subpoena for that. Or if we are going to go, to where you look at historical data, we think, it's easy for the town of Highland Park just to pull the July and August for, the years that you think are sufficient, Your Honor. So everything was installed in July. They think we overwatered, so you would want to look at July to August, obviously for 2023. But if they want 22 or 24, I would think July and August for each of those years would be sufficient, not over 36 months of data.
I tend to agree that's probably what would be relevant, probably, though I'm not sure. I haven't looked at and I don't recall the exactly when summer really started to hit, because the weather has changed so much. We're going to have 100-degree weather in May this year, apparently. So things are changing so rapidly, unfortunately. So I'm going to allow I'm going to allow the request. So I'm going to grant the motion to compel, and just understand what's good for the goose is good for the gander. 3 years is generally on these types of things is what I allow. So if you have the same dispute coming in the other way, it'll probably be granted that time period. So do you have a proposed order, Mr. Pugh?
I do, Your Honor. I believe we have filed it. I can send it. I have Ms. Rieger's email, and I can send it to her also.
No, it would. You don't need to. Let me see from the order. All right, that looks fine. Rhonda, I just can't print anything right now. Let me see. Can you print out the 4/17 proposed order of 2020? Yes. Go ahead and print that out. All right. Thank you, guys. You have a great rest of your day, okay?
Thank you.
Thank you, Judge.
And Judge, congrats to your daughter for